5:41 p.m. In accordance with the Texas Open Meetings Act, Texas Government Code, Chapter 551, this meeting is officially open with the quorum present. And we have no speakers this evening, so we'll move on to Level 3 grievances. We will move to Agenda Item 3A1A, the Level 3 grievance of Terrence Roach. Will the parties involved in this process please come forward at this time?
All right. Good evening. My name is Alex Adarwumi, and I'll serve as the officer for this hearing. Purpose of this portion of the meeting is to hear the Level 3 complaint of Mr. Terrence Roach. This hearing is being conducted during a duly called meeting of the Fort Worth Independent School District. Trustees convened on Tuesday, April 16, 2024. This hearing is being held pursuant to the district's complaint policies. Prior to this board meeting, proceeding re-hearing, the board may meet with its counsel to discuss procedural steps involved with this Level 3 appeals hearing, pursuant to Government Code Section 551.071. Does the board perceive that it will move to a closed session to discuss with its attorney any of the matters related to today's hearing? All right, thank you. Notice of this meeting provided in accordance with the Texas Open Meetings Act. For the record, a quorum is present. The following board members present. Wallace Bridges. Okay. I recant that last statement. Wallace Bridges is, but the following board members are present. Ann Dar, Lubanos, Roxanne Martinez, Quentin Phillips, Dr. Camille Rodriguez, and Dr. Michael Ryan. We are consider the Level 3 complaint of Mr. Terrence Roach, as I mentioned earlier. Mr. Roach, would you and any representative with you please state your name for the record?
Terry Roach.
Would you prefer to go here, Terrence Roach?
Terry Roach.
Okay. Will the individual responding on behalf of the nation please state your name for the record?
Linda Jackson.
Thank you, Ms. Jackson. I will now ask each member of this board whether he or she will serve as an impartial member of this body and to a decision based solely upon the record in this matter and information presented at this meeting, and not on information he or she may have heard prior to this meeting. Any member not able to serve should say so now and ask A recording of this must be made. Please, I ask that you please avoid, talking when others are speaking, so will reflect the proceedings accurately. This hearing will be conducted in open as follows. Mr. Roach and administration will each have a total of 10 minutes of presentations to the board. This is not a formal legal proceeding, so no rules of evidence or procedure will apply. Also, there's no cross-examination. The board is not to consider documentation claims not previously submitted or is not previously. There will be an opportunity for us to ask questions. However, members are not subjected by the complainant, administration, or legal counsel. As the complainant, Ms. will present first. I will time for presentation and will note if you have 2 minutes from. Would you prefer someone else keep track of it myself?
Does not matter.
Any time for 10 minutes after your presentation can be used for rebuttal after the administration's response. The administration will follow Mr. Initial presentation. I will allow you when you have 2 minutes. Or would you prefer myself keep track of time?
You may keep track of like my marker to be minutes, please.
Okay, thank you for that clarification. Anything of your 10 minutes after your initial can be used by you after Mr. Rebuttal. In the presentations, they'll be in closed session, counsel for advice, then return to deliberation, if any. Does anyone have any questions or initial matters that need to be discussed? Okay, Mr. Roach, you may proceed with your 10 minutes.
Thank you.
Just a moment. In benefit to you, we'll begin.
Thank you. But to your claim that this matter is being acted pursuant to the district policy, possible. This is ostensibly level 3 grievance hearing, but I'm here tonight. My name is attached to this level grievance. I did not file this. I did not level 1. I did not have 2 meeting, and I absolutely didn't give a response, so-called, your part, level 2, that you happened. I received any within prescribed time of 10. Board never had. There are more injustices to face than my case. There is no case cited evidence, facts, sense. District a grievance stakeholder. The stakeholders can and violating the right to issue a rule in 10 days. No other reason these blatant district grievance process. You should, in my favor, and their message to leadership. You voted against for their lackiness. That you apply the standard, the same to the its lack of time. A little about me. Back quite a ways back with D and with Earth, especially the West Side, thinking as Neiman Mark. With Fort Worth ISD of 96, formal career. ISD came to 2019. It's 5 years full-time school, 2 at Heights, South Hills. Subbed extensively. I could say I was at every single traditional middle school and in the district. With ISD was always, I moved away. I went to education and other things. I always have been hired probably by Fort Worth ISD, exaggeration. Thousands, tens of thousands of interactions and students and time. What is the nature of this grievance? Talking about on a form for hire. That's why I'm in doesn't make sense. Doesn't make sense. And this grievance, I filed in 2019. I was teaching at South every day for that evaluation. When I filed a grievance. It was the one grievance that was told in the grievance. I was at fault for nothing. I was ready every day. They do my evaluation. I was at fault. Refused the evaluation. But let that say. Filing because I didn't get an evaluation, being told I was what I'm filing agreements. That's been. Just had the privilege of working with colleagues and the rewards. It's a bit embarrassing to this case. It's something that I owe, but I'll get an opportunity to speak half. I've been doing, and that's without everything for my hire is. When the district, I was employed. You can listen to that. There's a recording. I don't know why that's not it, but that's accurate. I claimed about getting the contract when I should have had a. Rincon, you counted it. Thing I claimed about attendance. It's not an allegation. Letters there, your inboxes. This is clearly. When I knew what was me, I knew it was happening. So I looked in, stood up from, and one administrator brought us here. Same administrator found to be in violation of the TEA rule, and who submitted a pack. Heard anything in the pack about experience? What we've heard didn't have the sign, didn't turn in lessons. Get the 450 of planning time, certainly related to some plans. Every accusation, allegation, including not putting them away. I went to pursued education and other opportunities. I always came back. I've been hired probably 10 times by Fort Worth ISD without exaggeration. Tens of thousands of hours of interaction with parents and students and classroom time. And what is the nature of this grievance? And we're talking about a question on a form for rehire. That's why you're telling me I'm ineligible? Doesn't make sense. Doesn't make sense. didn't file this grievance. I filed a grievance in 2019 when I was teaching at South Hills. Every day I was ready for that test evaluation. When it never came, I filed a grievance there. That was the one grievance I filed. At that point, I was told in the grievance process that I was at fault as a teacher for not getting the administrators. I was ready every day. They never came to do my evaluation. I was at fault because I refused the evaluation. A teacher would let that sink in. Filing a grievance because I didn't get an evaluation, being told I refused what I'm filing a grievance. It'll make your head spin. Just want to say I've had the privilege of working with great colleagues and the students, the rewards. It's been embarrassing to be here at this case, especially with something that I didn't file. I could have said no, but I'll come along as an opportunity to speak on behalf. And that's what I've been doing, and that's what this is about. Everything from my rehire is absurd. When the district claimed I wasn't employed, I was employed. You can listen to that level 1. There's a recording. You have the recording. I don't know why that's not in your packet, but I sent you that packet. Everything I claimed about getting the wrong contracts, probationary, when I should have had a continuing. Mr. Rincon, your counsel admitted it. Everything I claimed about attendance fraud. It's not an allegation. The TEA letter's there. You've got it in your inboxes. This is clear retaliation. When I knew what was happening to me, I knew it was happening to other teachers, so I looked into it. I stood up for my rights, and one administrator brought us here. The same administrator who was found to be in violation of the TEA ruling is the only one who's submitted a packet. Never heard anything in the packet about classroom experience. What we've heard is didn't have the signs in his room, didn't turn in lesson plans. I didn't get the 450-minute of planning time, certainly related to lesson plans. Every accusation I've made, allegation, including this board, not putting public comments where they should be, every one of them is proven right. You might not like my personality, but tell me where I'm wrong. Tell me where in this district I've violated a rule. You've violated the rules. The TEA has brought that to be clear. Apologize for being a little disjointed. I'm reviewing notes very quickly. From the year that at South Hills from which any claim against me arises, there's no documentation by those administrators who make claims against me. They didn't write anything. Trustee Dar's colleague from the regional center was sent out to coach me. He was extensive in my classroom, and Trustee Dar can affirm this, that he gave me, but you can get on the phone. You can make a face, you can get on the phone and confirm that with Mr. Jackson. We had emails going back and forth. I have written reviews of him when he was out there that my classroom performance has always been top-notch. No one is perfect. But this is an embarrassment to the district to pursue a case against a teacher. You're telling me that I'm not hired because I didn't answer a question correctly on the application. Problem is, the question you claim was there is not there. Are you here to avoid your loved ones this evening? Are you? No, you're not here to avoid your loved ones. But you are here in lieu of your loved ones, which means in place of. You can't be two places at once. So that question that I answered on that, which is the only kernel of truth that's left, and everything else has been proven false by this district, any claim against me. And all my whistleblowing has proven I'm not blowing smoke. I'm telling the truth, and I'm advocating for kids from outside the classroom now, making sure you're doing the best thing for them. How much time do I have left, please?
About 3 minutes.
Thank you. You can hear in the level 1 that I spoke with Mr. Rincon. She said, why at that time didn't you bring your complaint to the board? Well, I didn't have the results of a TEA investigation at that time to substantiate everything I said. But I told her, who wants to come before a board on an occasion like this? Not many people. I trusted this district to respect my rights as a teacher. When you respect your rights as a teacher, you're doing the best thing for the teachers, and that goes to students, makes for better educational outcomes. I endured a hostile work environment.
Pardon me, Mr. Roach, you have about 2 minutes left.
Thank you. I did my best every day. There's not one claim from anything in the classroom. And all the claims that you've made regarding 450 minutes of planning time, it's proven that I didn't get it, and a lot of teachers didn't get it. Attendance fraud. TEA investigation proved that was true. This idea of assigning a grievance to a stakeholder, again, that alone should turn this back. Ms. Rincon said, well, it wouldn't be timely, but I just wonder why you wouldn't pursue it now. If that's not timely, how is this timely? What kind of a grievance is this? Who filed this? I never get an answer. It's either staff, someone from the office of district leadership. No one will stand up and tell me why I'm ineligible, because we all know the reason. I'm ineligible because I'm a whistleblower who's done the most that I can, and we can all do more, to advocate for the students. And I did that throughout my career. This isn't about me, really. Probationary contracts were going after the wrong people all the time. The 450 minutes, I wasn't the only one suffering that. This is about this board restoring some integrity and saying, hey, there's a limit to how, we have a teacher who's 15 years in the classroom, we need a good reason why he's not eligible for rehire. Not this nonsense. If it were even true that I wrongly answered a question on it's not, but if it were true, you're telling me that's like Allen Iverson getting up. We're talking about practice. We're talking about one question on an interview. You kidding me? We're talking about one question.
Mr. Roach, I'm going to
Yes,
have to
sir.
let you know that the time allotted for your initial presentation is now elapsed.
Thank you.
I'm going to turn the floor over to Ms. Jackson. And just a moment for me to let you know when your time is go. You may begin.
Thank you. Good afternoon, trustees. Thank you for your time this evening. This grievance is really a simple issue. The district has the right to establish rehire eligibility criteria. One of the criteria that this district has chosen to use is truthfulness on the employment application. Mr. Roach received a notice, it's on page 34 of your exhibit, on March 22nd of 2019. That letter, that is in your packet on page 34, I will read a portion of it, and it says, the Board of Trustees will consider the proposed termination of your probationary contract at its meeting, which is scheduled for Tuesday, April 23rd at 2019. The next paragraph says, if you wish, you may choose to resign as an alternative. So he had the choice, either accept the fact that we were bringing to this board and motion to have him terminated, or he could resign. Mr. Roach elected to resign. On page 36 of your record, he emailed his intent to resign with stipulations. He wanted the reprimand removed from his file. He didn't want to have any issue with being rehired. None of those stipulations were granted to him. He still pursued the retirement and the resignation. And on April the 25th, he submitted the Form 100 saying he was resigning to pursue other interests. In November of 2022, Mr. Roach applied for another position to return to the district. That is exhibit page 54 in your packet. The employment application specifically states one of the questions that he is supposed to answer is this notion of, have you and again, I'm reading directly from the application. Have you failed to there's a certification that requires that you disclose you have been truthful in your application, but then it specifically states, have you ever failed to be rehired, been asked to resign a position, resigned to avoid termination, or terminated from employment? He answered the question, no. That was not an accurate statement. He had, in fact, been proposed for termination, given the opportunity to resign as an alternative, and he accepted that alternative. The latter part of the application, where your signature is required, attests that you are telling the truth, and it specifically states, again, this is on page 57 of your exhibit, I certify that the information given by me in this application is true in all respects, and I agree that if the information given is found to be false in any way, it shall be considered sufficient cause for denial of employment or discharge. Clearly, that was a standard. You certified that what you were saying was truthful, and the application identified the consequences if you were not truthful. So to his application that was submitted in November, the district responded and said he was not eligible for rehire because he had, in fact, not answered truthfully on the application. That's the whole crux of this issue of why we're here. In response to his concerns that he never had a level 1, he never filed a grievance, I would direct your attention to a specific exhibit in the packet. On page 95, we actually submit the response, which he says he never received. We actually have as an exhibit in your packet, exhibit 16 on page 103 is his letter asking for his level 2 hearing. So if at any point in time he decided that he did not want to pursue this grievance, all he had to say was, I withdraw the complaint. The reason why it was assigned as a general public complaint is because once Mr. Roach received the communication from the Human Resources Department saying he was ineligible, he continued to pursue contacting various members of the organization asking, why am I not eligible for rehire? Why am I not eligible for rehire? Chief of Risk, Ethics, and Compliance at that time had multiple conversations and a lengthy meeting with Mr. Roach to explain to him why he was not eligible for rehire. He continued to write and inquire, why am I not eligible for rehire? At that point, we decided, we being the Chief of Risk, Ethics, and Compliance, in consultation with the legal department, decided—
5 minutes remaining.
Thank you. If he still wants to pursue this, the only alternative he has available to him is the grievance process. And so we wrote a letter to Mr. Roach and said, you're continuing to raise this issue. Leadership has already answered your issue, but if you want to pursue it, the only avenue left for you is the general grievance process. In this instance, because you have already had a lengthy meeting with Chief Rincon, we are proposing that you start at level 2, and we assign the hearing to, and then Chief of Talent Management, which was Raul Pena. So this is how we got through the grievance process. Mr. Roach would not take no for an answer. He knew the reason why he was not rehired, why he was not eligible for rehire. He disagreed with that. And as he continued to push the issue, we simply availed him of the proper process to have that issue heard, and that is why we are here tonight. We would ask that you uphold the district's decision that he remain ineligible for rehire because of the falsification on his application submitted in November of 2022. Thank you.
Thank you. Mr. Roach, there's 0 minutes remaining for you to present any rebuttal. So I'm going to turn the floor back over to Ms. Jackson and ask if you would like to offer any rebuttal. If so, you have about roughly 4 minutes left for what wouldn't be a rebuttal at this point, but if you have any additional comments.
Thank you. I have
Counsel,
no
I'm
additional
confused. Would you explain this again to me? I've had 10 minutes, correct?
That's correct.
For presentation. In your explanation of the parameters here, I don't believe you told me that use of the entire 10 minutes would take away from any rebuttal. I believe you referred to I would have the opportunity for a rebuttal. Is that not correct?
I'd like to clarify my statements to the extent that you misunderstood them. I said any of your 10 minutes remaining would be used as part of your rebuttal. So that's why I notified you that you had 2 minutes remaining. At that time, you could have reserved any further commentary and used that 2 minutes for your rebuttal. But right now, you have 0 minutes left.
When you use the term rebuttal, you've established that there will be a rebuttal. My understanding was that any time that I didn't use that, perhaps, for example, you're allotting 2 minutes for rebuttal. And my understanding is that if I only used 8 minutes, I would have 2 minutes to go toward rebuttal. I think it's incumbent upon you to explain to me that if you're using the term rebuttal, that there may be no rebuttal if I choose to use the full 10 minutes, which you told me was allotted to me. But that allotment includes a penalty. If respectful of me as a stakeholder, I insist that you provide some time for rebuttal in light of your failure to clearly enunciate, to clearly tell me what the rules are.
Just a moment, Mr. Roach. All right, I appreciate your comments, Mr. Roach. I'm going to say that apologize for any misunderstandings you may have with my comments earlier. I'm going to allot 1 minute for your rebuttal. To the extent you have any, do you have any comments to offer?
I appreciate it.
Well, just give me a second. I want to make sure that I have our time down correctly. So are you going to offer a rebuttal?
Yes.
Okay, give me a second to start your time. Do you mind? The floor is yours.
And your example is appreciated of leadership. When we make mistakes, when partial responsibility, we step up to it. Again, we're hearing that to this juxtaposition, they don't mean the same thing. In lieu of, had the question been, did you resign in lieu of proceedings? Yes. To avoid imputes a motive on me. I've never met Ms. Jackson. She doesn't know me. And respectfully, you are not one to tell me what my motive was. It was not to avoid any termination, to move on and not be at a situation like this.
20 seconds remaining.
Talk about availing me of the proper process by throwing me into the middle of precluding my ability to have a fair and equitable level 1 grievance. That's what happened. They didn't advise me. They took me and put me in the middle of the process without my consent.
Thank you, Mr. Roach. I will now turn the floor over to Ms. Jackson, who has 4 minutes allotted for her commentary if she has any.
Thank you. This is a classic example of what happens when we try to engage in dialogue about this process with Mr. Roach. I believe the script was clear on how the time was to be allocated. We believe that the district was clear in what the requirements were in order to be eligible for rehire, and that Mr. Roach violated those requirements when he answered the question, no. He had in fact resigned as an alternative, which is what his letter said, as an alternative to being terminated. So when the question was asked, his responsibility was to answer yes. Instead, he wants to take us down this road, this rabbit trail of in lieu of versus in order to avoid and assigning motive. That is not the issue. The issue is read the plain language of the application. He checked no, the district made a decision that he was not eligible for rehire, and that is the conclusion of that matter. None of the other issues were relevant to this particular determination, and again, I've explained why he is in the grievance process, because he continued to address various stakeholders in the organization wanting an answer. So we said, if you believe you've not been heard and you still want an answer, despite the fact that we think we've given you one, this is the only process we have available for you to continue and to pursue that issue. At any time, again, he could have withdrawn his grievance and said, I no longer wish to be in this process, or you put me erroneously in this process. I don't want to participate. That would have been acceptable to us. In fact, he did file a level 2, and he also filed a level 3 appeal to this board. So because of that, we would ask that you uphold our decision, the district's decision to establish the criteria and to continue to hold Mr. Roach ineligible for rehire with the district. Thank you.
Thank you, Ms. Jackson. Does that conclude your presentation?
Yes, sir, it does.
Thank you. Does the board have any questions of the parties? Having looked around the room, I take it that there are no questions from the board to any of the parties here. This concludes the hearing portion of this proceeding. Following the conclusion of all grievances, the board will move to closed session to consult with the board's attorney pursuant to sections 551.071 and 551.0821 of the Texas Government Code. The board will then reconvene into open session to deliberate and take action, if appropriate.
If there are no additional questions, we will take a 5-minute recess. We are back in session at 6:24, and now we're on to agenda item 3A1B, the level 3 grievance of Joe Palmer. Will the parties involved in this process please come forward at this time? Mr. Palmer is not present at the moment. We will continue on to yeah. Will the parties involved in the level 3 grievance of Gary Clayton please come forward at this time? My apologies, we were going to have to move to closed session. So at this time, the time is 6:26 p.m. and we are recessed to closed session. Authorize. And that's it.
That's it.
Now we will continue with agenda item 3A1D, a level 3 grievance of Latanya Lewis, which requires meeting in closed session as authorized under Chapter 551 of the Texas Government Code, Sections 551.074 and 551.072. Will the parties involved with the level 3 grievance of Latanya Lewis please move forward at this time? And the time is 7:14. We will move to closed session. Now we're to agenda item 3A1B, the level 3 grievance of Joe Palmer. Will the parties involved in this process please come forward at this time?
Good to go. All right. Good evening. My name is Alex Adewumi, and I will serve as the presiding officer for this hearing. The purpose of this portion of the meeting is to hear the level 3 complaint of Mr. Joe Palmer. This hearing is being conducted during a duly called meeting of the Fort Worth Independent School District Board of Trustees convened on Tuesday, April 16th, 2024. This hearing is being held pursuant to the district's complaint policies. Notice of this meeting was provided in accordance with the Texas Open Meetings Act. For the record, a quorum is present, and the following board members are present: Ann Dar, Anel Luabanos, Roxanne Martinez, Quentin Phillips, Dr. Camille Rodriguez, and Dr. Michael Ryan. We are meeting to consider the level 3 complaint of Mr. Joe Palmer. Mr. Palmer, are you here? Mr. Palmer, if you're here, would you come forward? I'd like the record to reflect that Mr. Palmer did not come forward. Are there any individuals here responding on behalf of the administration? If so, would you please state your name for the record?
Linda Jackson on behalf of administration.
Thank you. I will now ask each member of the board whether he or she is able to serve as an impartial member of this body and arrive at a decision based solely upon the record in this matter and information presented at this meeting, and not on any other information he or she may have heard prior to this meeting. Any member not able to serve should say so now and ask to be excused. Having scanned the room and noticing that no one's asked to be excused, I'll continue. A recording of this hearing must be made. Please avoid talking when others are speaking so that the recording will reflect the proceedings accurately. This hearing will be conducted in open session as follows. Mr. Palmer and the administration will each have a total of 10 minutes to make their presentations to the board. This is not a formal legal proceeding, so no strict rules of evidence or procedure will apply. Also, there is no cross-examination. The board is not required to consider documentation or claims not previously submitted or issues not previously raised. There will be an opportunity for board members to ask questions. However, board members are not subject to questioning by the complainant, administration, or legal counsel. As the complainant, Mr. Palmer would have went first, but he's not here, so I will turn the floor over to Ms. Jackson. I will keep the time for her presentation and will notify Ms. Jackson when she has 2 minutes remaining. Any time remaining of her 10 minutes would have been used for a rebuttal, but since there's no rebuttal to be offered, we're just going to keep moving forward. Following the presentation by Ms. Jackson, the board will move to a closed session with its counsel for advice and may then return to open session to deliberate and take any action if necessary. Does anyone have any questions or concerns or comments about the initial procedures before we begin? That said, Ms. Jackson, the floor is yours.
Thank you. Good afternoon, good evening again, trustees. Thank you for the opportunity to represent the district in this level 3 hearing of Mr. Palmer. I'll begin with some words that may be familiar to you, having read the record and listened to the recording. That's one warning, Mr. Palmer. Would you like to sit down or would you like to leave? Call for the next speaker, Ms. Super. Mr. Palmer continues to yell from the audience. You ask me a question. I want to answer. I don't think I should have to leave. I've asked you to leave. Thank you. I've warned you, and now I'm asking you to leave. This is the substance of the board meeting that occurred on January the 23rd of 2023. Joe Palmer was assigned to speak in public comment. He was given his 3 minutes to present his information. When the time was up, He moved from the podium but continued to yell out from the audience. The then chairman asked him to please be quiet and sit down. He continued to yell out. The next speaker had already been called and approached the podium and was trying to begin her remarks, but Mr. Palmer was still being disruptive to the meeting. The chairman then asked that he be removed. The dispute centered around whether or not he was asked to sit down and leave the meeting, or whether that was a direction for him to be removed. Mr. Palmer, the only information you have representing his position is the grievance that is before you, his written statement, and the remedy that he requested. Since that time, the board has taken several actions to be clear on what would constitute grounds for removal from the meeting. I will remind the board that you have adopted clear warning language that the board president reads each time there is a disturbance, specifically stating this is a warning, and if the behavior continues, you may be removed from the meeting. Since that time, you have also adopted written guidelines for conduct during the meeting. The information is posted on the visual boards in the room before the board meetings start. And there's clear direction that if anyone violates that code of conduct, they may be removed from the meeting after given a warning. Because of that, we believe that any concerns or confusion that Mr. Palmer or any other public speaker may have about what is allowed and is not has clearly been addressed. Rules have been published. When speakers sign up, they know now what the expected behavior is. They also know the consequence if they don't follow those rules. So because of that, and because you have taken the steps that you have to clarify expectations for meeting conduct and consequences when those expectations are not met, the district believes, its administration's belief, that you have fulfilled your obligation. And we would ask that Mr. Palmer's grievance be dismissed in its entirety. Thank you. Yes, sir, it does.
Thank you. I noticed in policy GF legal, it specifically states that under the heading of disruption, it is a criminal offense for a person with intent to prevent or disrupt a lawful meeting to substantially obstruct or interfere with the ordinary conduct of a meeting by physical action or verbal utterance and thereby curtail the exercise of others' First Amendment rights. Were any criminal charges filed against Mr. Palmer?
No criminal charges were filed against Mr. Palmer.
Okay, thank you.
Any other questions by board members? Having scanned the room for any additional questions and seeing that there are none, this concludes the hearing portion of this proceeding. Following the conclusion of all grievances, the board will move to closed session to consult with the board's attorney pursuant to sections 551.071 and 551.0821 of the Texas Government Code. The board will then reconvene into open session to deliberate and take action if appropriate. The board may now move to consult with its attorney in closed session. And with that being said, Ms. Jackson, you are excused.
Thank you.
Thank you.
The time is 8:03 p.m. The date is Tuesday, April 16, 2024. We will now recess and reconvene for executive session as authorized by Chapter 551 of the Texas Government Code under Sections 551.071, 074, and 082. In accordance with the open meetings law, the board opened the meeting at 5:41 p.m. with the quorum present, recessed and reconvened open session, adjourned regular session, convened executive session, adjourned executive session, and now reconvened open session at 10:20 p.m. with the quorum present. Now we'll move into action item 5A. The board deliberates and render decision, if any, on the level 3 grievance of Terry Roach. Do I have a motion on the level 3 grievance of Terrence Roach? Okay, we'll move on. No motion, we'll move on to action item 5B, board deliberations and render decision, if any, on the level 3 grievance of Joe Palmer. Do I have a motion on the level 3 grievance of Joe Palmer?
I move to take no action on this grievance.
Do I have a second? Trustee Ryan, any discussion? Please move to voting. Motion carries unanimously. Next item, action item 5C, board deliberations and render decision on the level 3 grievance of Gary Clayton. Do I have a motion on the level 3 grievance of Gary Clayton?
Yes, ma'am. I move that we send the allegations of the level 3 grievance to the district UIL committee for their consideration.
Do I have a second? Trustee Martinez, any discussion? Please move to voting. Motion carries unanimously. Move to action item 5D, board deliberation render decision on level 3 grievance of Latanya Lewis. Do I have a motion on the level 3 grievance of Latanya Lewis? There is no motion. At this time, the time is 10:22, and this meeting is adjourned.